So without further ado, I want to welcome everybody to this week's topic. Thank you for taking time out of your busy schedules to join us. If you have not been on this topic series, we broke it up because this is one of the conversations and topics I do when I'm doing retirement planning classes. When I was at Rutgers at their business school promoting this was the section that we did. The topic is important, but it's voluminous. And so because it's a lot of information, we took, the content and broke it up into 4 different subject matters. So sit back, relax, welcome. So without further ado, we'll get started. So the original recording is on LinkedIn and YouTube. We recorded that on 7/7, and it was estate planning basics. Today, we're going to talk about probate and trusts. And then ideally, we would say, hey, next week, we're going to do part 3, the Secure Act, but that probably will not happen because next week, I think we will do a market update, which is a recap of the month of July. And then we'll get caught up. So, if you see the topic come out there and it's on this topic of wills and trusts, mark your calendars and make it if you can. Otherwise, we will record. So, probates and trusts, what we'll cover today. What is probate? Advantages, disadvantages of probate, estate exemptions, and various types of trust. So, as I said, there's a lot of content here. So what is probate? So probate is a legal process meant to identify the value of the assets upon your death and to determine how the assets get distributed. The degree to which the court supervises the process of probate varies by state. Generally, only individually owned assets are subject to the probate process, unlike joint assets and beneficiary designated assets. And I'll explain that a little bit deeper in a few slides. So recap, last week on 7/7, last call in this series, we talked about a couple, Sean and Mary. They 58-year-old couple, they had 3 children. One had poor spending habits, they have some assets, and Sean passed away. We answered the question of what happens if they did not have an estate plan and what will happen if they did not have a will. So that's already been gone over. Here's a sort of high level overview of what they had. They had a joint home, they had a hunting camp, $75,000. They had joint investments. Sean had an IRA, named beneficiaries. Mary had an IRA, named beneficiary. Some bank accounts in Sean's name, bank accounts in Mary's name, joint bank accounts, and then Sean had a life insurance policies, but that named beneficiaries. So advantages of probate. Provides court supervision if it's necessary, generally limits the time in which the will can be challenged and creditors can make claims against your estate, determines the validity of the will, and carries out your final wishes. Disadvantages of probate. They're expensive, right? When things go through, I always ask this question when folks are in my office. I'm like, name one thing that New Jersey manages well. And it's not just New Jersey, most states, right, are filled with red tape and bureaucracy and, oversight and governments and layers, right? So those systems, right, I normally will sit and pause when I ask that question, name one thing that New Jersey manages well, and I shut up. Typically, I don't get an answer. And I go, exactly. So if New Jersey can't manage their own affairs smoothly, how well do you think you're going to do with your estate upon your death? It's important to have wills. Now, whether you need a trust or not, that's another question, but at least at a bare minimum, having a will, giving direction. Probate is a public process. This is another key factor that, a lot of people think, oh, it's no big deal. But when you think about it, there's a lot of, nosy Nellies out there that how much did they have? Where were their assets? When you go through probate, that is all public information. Assets are subject to probate may not be available to beneficiaries or heirs for months, even years. And I've seen that firsthand as I've witnessed, people that have passed, settling of, getting, estate settled, getting it through probate. Now, I'll be honest, New Jersey's not awful, expensive, but not awful compared to some other states that I've heard some horror stories about. But it's still, this is taking something which is tragic, death, right? The loss of a loved one. And to add insult to injury, after you have the celebration of life and a funeral and, ceremonies, now you're trying to go through the paperwork, you're trying to find things. And, and as it starts to take months, even years to settle that stuff, it can be, concerning. So recap, Sean passes away. Sean has passed, leaving behind his wife and 3 children. Remember that Sean and Mary did not have their own estate plan. In general, dying without your own estate plan means that your family gets subjected to laws of intestacy, the government's way of deciding how your assets will get divided and distributing upon your death. Bottom line is, the government knows better than you. They know what you want versus you, because you did not put it in writing. Okay. So what if Sean had had a will? In the will, he could have provided instructions for the distribution of his estate upon his death and appointed a person, an executor, an executrix, a personal representative to administer his estate, right? So just by putting these people or positions in place, it would have avoided a lot of issues. Now, so this is where, I had somebody the other day call me, one of my advisors, that did some estate planning 20 years ago. They have some life insurance by the tune of a second to die, about $5 million. But their net worth is only, like he said, well, they're worth about 10 million, right? And he was asking me if there's anything that can or should be done here. And I said, under the current estate environment, there's really nothing to do. They actually took protocols or developed a strategy when the tax laws were less favorable. So 20 years ago, in 2001, 2002, 2003, the thresholds were 675,000 at the beginning of that decade, right? And over the course of 10 years, they elevated up to, several million. I think it was like 5 million. So a combined household of 10 million could be exempt from estate taxes. Then they did away with the estate tax for, I think, 2010. That was the 1 year if you passed away, it didn't matter the size of your estate. And then they went back and started to put in and built in. Now, right now, the way it stands, each person in a married household, it's $11 million or $23 million for a married couple before estate taxes come out. That's under current law. So in my example where I said, hey, listen, somebody's worth 10 plus had a $5 million second to die, combined all in, that's 15 million. They're still under the threshold. That's why there really was nothing to do. Now, there's talk, and the government, we've talked about this ad nauseum, that, the government is, and we hear about it daily, is spending, that they need money for this, for that program. And we're actually in one of the lowest tax brackets that we've been in the last 100 years, right? People don't realize that. So if the government is starved for money, they're going to start to go to places. They've already talked about that they want to add a whole bunch of new IRS agents looking to go after small businesses to increase the amount of revenue that they generate. That's going to yield, X amount. But they're also going to start to revisit some of the existing level of estate tax law. It is a very large arena for taxation, and it's open. So if they go back and adjust this from, say, 23 million, I have no idea to where they were. Let's say they go back to what it was, 5 million each. So now it's 10 million. Well, then that family that I gave you before now has the potential for estate taxation risk, right? And those estate tax environments can be pretty hefty, pretty quick. We start talking estates in excess of whatever that threshold is, can be 50, 60. It's been as high as 80 to 90% So, and people don't understand that that's where the confiscation of wealth is from transfer from generation to generation, if not properly structured, can create a loss of wealth. And, I know I went down a rabbit hole right there, but that's why, when we start talking about estate taxes in current environment, most people don't have the foresight to start to put mechanisms in place to preserve the wealth for their family circle of wealth. And that's just federal, not to mention state. And you see that New Jersey is named there as a state that has an inheritance tax. It starts to add up. And, there's just different philosophies. But again, folks have worked hard building and amassing wealth, building and amassing a assets, right? That they want to pass their children, their grandchildren, nieces, nephews, charities, whatever you choose to do. But if you don't dot your I's during this process and cross your T's, inadvertently, you can have a leak in your overall plan, and it could end up having a negative effect and not going where you want it to do. So that's my little down a rabbit hole comment there. But what if Sean had a trust? What does that do? A trust is a legal entity that can be created to hold title to your assets to be managed and distributed under the rules set forth in the trust. There are many types of trusts, and this is where it gets confusing. All trusts have three parties. You have the settlor, you have the trustee, and the beneficiary, right? So the settlor is a person that's creating it, giving their assets away or putting them into a box. The way that I've always explained it, view a trust sort of as a box. And what you're doing is you're putting instructions inside of that box. Now, depending on the type of trust, you can have it revocable, irrevocable. We'll talk about that in a second. But then I'm giving that box in either myself, I own the box, I'm the trustee, or maybe somebody else is the trustee of the trust. And then ultimately that is for the benefit of somebody else. So that's just to help you to understand and envision how that works. Now, this page here, this is why estate planning and estate planning attorneys exist. It is a complex area of law. I met a 21, 22-year-old who's going to law school right now. And when asking what kind of law he should be pursuing, I said, you know what? It depends on what your goals are. But if you can learn and master tax law, elder care law, estate planning, you will do well, right? And it's because it is complex. But see over here on the left-hand side, you got revocable trust, right? And then two boxes down, irrevocable. Those are the two most common types, right? Either one, you can change your mind. So I did something, but I don't want to make it irreversible. And the other type is irreversible, right? That means that you are literally saying, hey, with this little bit of money that I'm putting over here into this box, right, with the instructions, that I am taking an arm's length step away from that asset, right? So that it cannot, anything that it creates or houses cannot be brought back into my overall estate, therefore subject to taxation. And why is that important? Is because with Medicare, right, there's what they call Medicare spend down trusts, right? So, a lot of people to qualify for Medicare and go on, a state's income, right, or become eligible through a state, right? That's Medicaid, right? Medicaid spend down. I use wrong nomenclature there. Medicaid, which is state, means that you turned around and you distance yourself, but there's a 5-year look back. So, a lot of times we have to do planning well in advance, right? To be able to develop strategies to preserve assets within a family, to make sure that the goals that mom and dad, grandma and grandpa wanted to happen actually happen. Because, and again, I've been doing this, I'm 30 years in this business. And one of the things I started to uncover along the way is that I would talk to my clients and roughly my age, and they would say, my parents have this asset or this money, or, they've accumulated this wealth. And what I started to realize what started to happen is that the parents of these people I was speaking to really didn't want to have any conversations almost until it was too late, because they still always psychologically always viewed this as, oh, you just want my money, or I got this, or we did this, or it's private, or they didn't discuss it. And then as things continued, they went from 75 maybe where they felt that way, and now they're 85 or 87, and they're starting to get to a point where they go, hey, listen, you know what? We're having to help mom. We're having to help dad. We want to preserve the estate, and maybe they might have to go into a nursing home or some type of nursing care. And the first thing they realize is all the assets that were in mom and dad's name, that the state is going to ask for payment, and they're going to assign those assets to the family, and they're going to consume them. And at that point, it's too late. So doing planning is very important. Everybody's circumstances is different, but I just the level and types of trust are extensive, and depending on what the goal is, the tax laws, there's a lot of strategies out there. And that's why, I'm a big proponent of, I don't have a problem paying my fair share of taxes, but if there's a way for me to take advantage using tax law to preserve a family's circle of wealth, I will absolutely encourage that. And then quite often we'll use an estate planning attorney or use the tools that we're talking about here to help do so. So testamentary trust. This is a very simple trust. It's a trust created within a person's last will and testament. I call it a springing trust because it's not a separate document. It's just language within the will, but it does require probate and is only funded upon death, right? Typically created for families with young children, right? Living trust. So a trust created while you're still alive, also known as inter vivos trust. There are numerous types of living trusts. However, the most common are, and this is what I was referring to before, revocable, you can change your mind, or irrevocable, you can't. Revocable trusts, there are advantages. Settler may revoke, right? Change your mind. Income tax reporting is simple. Assets included in the estate and receive a step up in basis. That's important, and they've looked to change some of these rules. It's definitely been, Congress and politicians have looked to this as a way to, get money in the past, and it will definitely be on the up for review in the future, I'm certain, with the debt that this country has run up. So income tax reporting is simple. Let's see. Settler often serves as a trustee and beneficiary of a revocable trust. So it's a trust, but they're also the person that's in charge and ultimately receives the benefit. Provides a better plan for incapacity. And that's the thing, is if you become incapacitated, that living trust can work because your instructions were already in place. Avoids probate for trust assets if properly funded. Disadvantages: provides no asset protection from creditors. So that's the thing, is that, there's, if you've run up debt, if you've caused harm or end up getting sued, or something happens where you end up owing somebody money, they're going to come after the estate, and a revocable trust can be subject to creditors, right? And then assets might not avoid estate taxes. Yep. Irrevocable trust. Advantages: assets may be transferred free of estate taxes. This is, again, strategies designed. They're also known as crummy trusts, right? Islets. There's a couple different names, but when you create this irrevocable trust for the purpose of preserving an estate, right? It's using the tax code, and it's been tested, challenged, and is common practice. The only thing that's really, it's sort of gone by the wayside in the last 20 years is because, as I mentioned earlier, that we each have, a little over $11 million if married. So $22-23 million. Most people don't have that level of estate. So the advanced ILA trusts that we used to do in the past are not necessarily commonplace today, but they may change those rules and they may come back into favor in the future. The settler may serve as a trustee, may be an income beneficiary. So that's a way to keep an arm's length, but you can still generate income out of the trust. Provides asset protection from creditors. That's why a lot of people do it. High income earners, net worth, physicians, people that have a lot to lose should consider something to this effect. Avoids probate for trust assets if properly funded. This is a really important one, right? Is that you just basically gain that privacy that we were talking about. And then you protect the assets from the nursing home. And again, sometimes, if you get enough in place or early enough in place, you can preserve a large portion of a family's estate. Disadvantages may require loss of control. That's the one that I've always heard is the objection, and that's why I was saying is that, quite often do irrevocable trust is you're giving up control. And I know how I am, right? Am I going to take my house and go put it into a document, right? I'm going to be hard pressed for you to convince me to do that right now. Now, 20 years from now, I start to go, you know what, I probably should consider that, right? Because it's preserving the estate. Well, it's the same thing with your parents and your grandparents, right? That folks that want to preserve assets, because I'm telling you, New Jersey and these other states, and there's laws that have been around that haven't been exercised, but a lot of states I've heard of late, they're called FILIA laws, which are, a lot of attorneys are doing these advanced type of strategies, Medicaid, spend down trusts, right? Where they're basically putting the assets of the family into these trusts, therefore impoverishing the family. But what some states are saying is, hey, listen, this is your mom and dad, you're still responsible for the bill. So they're not always bulletproof, but this is the thought process. May require relinquishment or direct access to assets. Settler may not revoke, modify, or amend the terms of the trust alone, right? So that's why you're giving up control again. And then income tax reporting may be more complicated. So those are some of the downsides. Here's my slides for the next upcoming weeks, as we talked about. Just want to say that, we're trying to, keep on schedule. So next week should be market update. Then we'll do part 3. 9/1 should be part 4 of this, and we'll wrap that up. So hopefully this was informative to you. Remember, don't keep us a secret. If you have any questions, if I can help, let us know. These are disclosures that I have to say, hey, listen, everything I said here, is based on approval through my compliance department. And then ultimately, there's my contact information. Folks, I hope all of you are well. Stay safe. If you need me, call me, and have a great day. Bye-bye.